esteemed Dean of CMR Law School, Dr. Subramanya, esteemed members of the teaching faculty, my beloved students. I am here to give an overview of the Criminal Procedure Code with specific reference to nature of trials and victim compensation. All of you know, you are still students. Many of you may join the legal profession and you may start your career as advocates. Procedural laws are quite important while conducting cases. The substantive laws which one has to press into service every now and then in court is supported by procedural laws. In criminal cases, it is the Criminal Procedure Code, and in civil cases, it is the Civil Procedure Code which has greater relevance in presenting the cases. Friends, the Criminal Procedure Code underwent a major change and it was replaced in the year 1974. The new Criminal Procedure Code of 1973 has come into effect from 1/4/1974. Subsequently, it has undergone radical amendments, very revolutionary amendments based on the recommendations of Law Commission as well as also the recommendations of Justice V.S. Malimat Committee on Criminal Amendments. Friends, most of you have already studied Criminal Procedure Code. May I know from you, on going through the entire Criminal Procedure Code, what do you feel? What is the object of the Criminal Procedure Code? Can anybody tell me in a nutshell? Even if you falter, no problem. I would like to correct you. On going through the entire adjective law of Criminal Procedure Code, what is the inference that should be drawn? Okay, no problem. The main object of Criminal Procedure Code is to provide a fair trial to the accused and justice to the victim. If you go through, the sections are framed in such a manner not only to provide the rights of the accused but also to protect the interest of the accused. For example, see, we have several judgments of the Supreme Court, right from Husainara, Khatun, First Court and other leading judgments. They all say accused has right, fair trial, quick trial, there should not be any delay, and all constitutional rights of an accused are safeguarded by means of wonderful judgments of the Supreme Court. Is it not? Charles Shobraj, it was a case in respect of solitary confinement. Supreme Court has said, Supreme Court has expanded the scope of Article 21 of the Constitution in the background of IPC as also CRPC. But we had virtually forgotten the victim. So now victim plays an important role, and because a definition is found for the first time in Criminal Procedure Code with the introduction of Section 2WA, which has come into effect from 2009. So victim. So in a criminal case, when a case is taken up for trial in a criminal court, there are very many stakeholders. The stakeholders are first the accused, second is the victim, third the witnesses who speak on behalf of the victim, the investigating agency, it may be police or it may be a special investigating agency or an investigating agency under the special penal law. Is it not? And the judge. And the stakeholders include the forensic science laboratory experts and experts of different domain. A doctor conducting postmortem will be an expert in terms of Section 45 of Evidence Act. His evidence will have to be assessed. A mint expert, an expert on a chemical analyst, a handwriting expert, a fingerprint expert. So these persons are the stakeholders. All of them have a say. But hitherto, most of the judgments, we don't find fault with the Supreme Court having discussed at length the various rights of the accused while undergoing trial. Well, even an accused till he is condemned has all right, even after he is condemned and sentenced, even when he is in prison, he has some constitutional rights. They will have to be safeguarded. There is no second opinion about it. At the same time, the victim, the plight of the victim is not known. The victim comes into picture only when he or she is called to the court. In some cases, victim is dead. Somebody will speak on behalf of the victim. Therefore, if you analyze the entire criminal procedure code and the major amendments which have taken place, the main object is to provide a fair trial. No accused should feel that he is not given a fair trial. No, trial was hushed up, or trial was held in such a manner that he was not given due and fair opportunity. So there must not be any scope for such criticism. So therefore, judge and others concerned with the trial must ensure that a fair trial is given. At the same time, the interest of the victim is also taken into consideration. For example, how many of you have visited courts while functioning? Have you visited some courts? Have you visited? Okay. Have you visited criminal courts? Magistrate courts in Bangalore? In Rupatunga Road? What is your opinion when you see magistrate courts? All courts are full, and see in the beginning of in the main door there will be a dafedar. He will be calling the names Ramanna, Bommanna, Timmanna, and there will be a policeman, mustached policeman standing there. And one victim comes, lady. Let us assume that an attempt was made to outrage her modesty. She comes before the court. She comes from a far off place. By the time she comes, it will be 10:40. She will go to the office of the prosecutor. He says, no, why have you come? And so late, it's very difficult. Now it's already 11 o'clock. Go to the court. She comes there to have to refresh herself about what was stated by her before the police under section 161 of CRPC. By the time she has a difficulty, she can't come so early because she has small 2 children. She has to travel about 30 kilometers, 25 kilometers, pay money. While sending the summons, will the judge send a check for travelling allowance and dearness allowance? How many of you have seen or heard of witnesses receiving the travelling allowances at DA? As a judge, in few cases I was giving, but no judge bothers about, since this is an in-house program, most of the judges do not bother about their plight. A lady has to stand, whether it is raining or a hot season, she has to come. She will have a small child she has to bring, and many a times it so happens a case is already fixed for a trial, it is taken up, and she had to wait till 4:30 only to be told that the case is urgent. Is it not? Only to be told that the case is urgent to such and such a date. Neither the court pays her the travelling allowance and DA, nor she is looked after. What should happen? Where should we find money? We do not know what her plight. She may be having a very small child, or maybe in an advanced pregnancy also. Therefore, for the first time, victim 2WA, victim compensation. Therefore, we talk of victim compensation. Now, today in papers, when Asaram is convicted, say, all right, it's convicted, sentenced, everything is okay, right? Though trial is delayed, okay, ultimately justice is given to the victim. But victim should be suitably compensated. What type of offence? An assault on a sexual assault on an innocent lady. A lady who was a follower of that godman is sexually assaulted. And do you know, she is dead for all. She is not only physically dead, she is mentally dead. She is a hapless lady. How to compensate her? Therefore, POCSO Act, Prevention of Offences Against Children from Sexual Offence Act, 2012. Now, separate section is found. Rules are made. Rule 7 of POCSO rules specifically mandates about the manner in which a victim is to be compensated. Friends, before going to the nature of trials, there are 4 types of trials. Can anybody say what are the trials? What are the 4 types of trials? Please, this is an interactive session. Summary trial, summons trial, warrant trial, sessions trial. Summary trial is found in section 260. Is it not? Then summons trial. What is summons trial? What is warrant trial? See, in the definition clause 2 of CRPC, you found some definitions. So definitions like cognizable offense, bailable offense, you all find it. Court, you find a definition. Victim, now you find a definition. But you don't find a definition of summary trial or a sessions trial, or summons trial or a warrant trial. You find only 2 definitions, that is summons case and warrant case. First of all, before understanding the nature of trial, you have to understand what is summons case and what is warrants case. What is summons case? If you go to the definition under section 2, summons case is one which is not a warrant case. It is not defined. It is an exclusion. That means that case which is not a warrant case is a summons case. So what is warrant case? Warrant case is one in which the punishment is 2 years and above, more than 2 years. So that is how summons case is defined. That means you will have to be thorough with the first schedule appended to CRPC. First schedule contains serial number, section of offence, nature of offence, punishment contemplated thereby, bailable or non-bailable, cognizable or non-cognizable, and the forum in which such case is tried. So you must, whenever a case comes, you will have to go to schedule 1 appended to CRPC. So that is in respect of, that is classification 1 is in respect of IPC offences, general offences under the Indian Penal Code. There are offences under the special statutes also. So classification 2 speaks about the special laws also. Same. What is the, it is dependent upon the quantum of punishment. For example, other laws. First is, if punishable with death, imprisonment for life or imprisonment for more than 7 years, it will be a cognizable offence, non-bailable, court of sessions. If punishable with imprisonment for 3 years and upwards but not more than 7 years, cognizable, non-bailable, magistrate of the first class. If punishable with imprisonment for less than 3 years or with fine only, non-cognizable, bailable, any magistrate. So this classification 2 found in appendix 1 is applicable only when a special statute is silent about the whether it is cognizable or bailable, cognizable or not, bailable or not. Suppose, let us example in NDPS Act. Though the punishment contemplated only can extend up to 6 months and fine up to rupees 10,000 in respect of certain offences. Suppose let us assume that a man has ganja of 950 grams or 999 grams. It is quantified as small quantity. So earlier this small quantity, then commercial quantity, they are all defined from I think 2001 amendment. Earlier to that there was no classification whether it was 1 gram or 10 kgs or 10,000 kgs. Offence used to be one and the same, and quantum of punishment used to be one and the same. Now, in the light of the classification of the quantum of NDPS, punishment is prescribed. So, though it is 6 months, it shall be tried as a warrant case. There is, because special law, there will say notwithstanding anything contained in criminal procedure code, non-obstante clause. Section 37 speaks about the bail provisions in NDPS. The very word starts, the very section starts, notwithstanding anything contained in Code of Criminal Procedure. That means this CRPC is exempted under the purview of the Act. Friends, so we will have to understand what is a summons case and what is a warrant case. So now summary trial, summons trial, warrant trial, sessions trial. What is summary trial? Summary trial and summons trial are one and the same. Trial is in relation to the manner in which a trial is held. For example, in summary trial and summons trial, the witnesses, whatever the witnesses say, they will not be recorded as it is. That is, no recording of evidence in the narrative form or in the form of question and answer. Normally, evidence will be recorded in a narrative form. Whatever is stated by the witness will be recorded. At times, the court may also put questions and answers may be elicited, and the question and answer may also find a place. So, this narrative form is used only in warrant case. So, if you go through, see, there is neither sessions case nor summary trial is defined in section 2. So, the nature of trial is dependent upon the classification of trial, classification of case. Whether if it is a warrant case, so it will have to be in the form of narrative, and the judge has the discretion to put questions and elicit answers. If it is a summons case, it is recording the summary of the evidence. Let us assume that Negotiable Instruments Act, Section 138 of Negotiable Instruments Act, if A has given a check to B and that check has bounced, he will have issued a notice, prior notice, statutory notice. Even after the service of notice, he doesn't pay back the money or takes up a frivolous stand, and a case will be filed before the competent magistrate court. So, the procedure contemplated for trying a case under section 138 of Negotiable Instruments is summary. I think section 136 or 133 of NI Act specifically mandates about the manner in which a trial is to be held. Because it's a special law. It has already spoken of. But even then, even if the trial is to be held summarily, and if the judge comes to the conclusion that it is not proper to conduct the case in a summary manner, as contemplated under section 133 or 136 of the Act, he or she can switch over to try the same as a summons case or a warrant case. Because section 259 of CRPC provides for a judge dealing with a summons case to switch over to a warrant case, and it should be in the beginning itself. Let us assume that halfway through the trial is over. Halfway through the trial is over in summary manner, and he or she then switches over to warrant case. Then witnesses will have to be recalled because they will have to be examined, cross-examined, and the evidence will have to be recorded in narrative manner. Section 260 of CRPC speaks about the application of summary trial in certain types of cases only. What are the types of cases to be tried summarily are indicated in section 260 of CRPC itself. Section 262 also mandates that no punishment exceeding 6 months be given. There is one inhibition, legal inhibition. For example, section 379 of IPC, 380 of IPC, 381 of IPC. 379 of IPC says theft. 380 of IPC speaks about theft in a house or where some. Then for section 379, the punishment contemplated can extend up to, sentence of imprisonment can extend up to 3 years. In respect of 380 and 381, it can extend up to 7 years. but still it is found in section 260 as a summary case. So if we go by section, it should be a warrant case, is it not? Because warrant case is dependent upon the quantum of punishment. Here the quantum of punishment exceeds 2 years, therefore it should have been tried as a warrant case, but it is found in section 260 to be tried summarily. Let us assume that the judge, now the accused takes lot of defense, and taking into consideration the gravity of the offence and the nature of the evidence to be let in, the judge feels that it is not advisable to proceed summarily, he or she can switch over either to summons case, to try it as a summons case, or as a warrant case under section 262. See, leverage is given to the judge. No line is drawn. It is not Lakshman Rekha. It is not Lakshman Rekha. Therefore, why I am giving a view of these things is that CRPC, if you look at it as a whole, it provides the rights of the accused. It is accusatorial. It provides rights of the victim. Inquisitorial. It gives some powers to police officers, executive magistrates. Chapter 10 proceedings, 107 to 145, 133, public nuisance, to avoid public nuisance. Executive magistrates like Tahsildars, Taluk executive magistrates, sub-division magistrates, and district magistrates have all powers under Chapter 10. It provides powers to executive magistrates. It gives powers, it confers power to police. So, for example, conducting an investigation in respect of cognizable offence, the police officer has a right to arrest an accused without obtaining warrant from the judge. But in respect of non-cognizable offence, he or she, the investigating officer, has to obtain consent from the jurisdictional magistrate. The manner in which the investigation is to be done, how statement is to be recorded, section 161, 162 of CRPC, how a confession of an accused is to be recorded. Let us assume that in a criminal case, accused comes forward to state that he would give a true account of what has happened, and let us also assume that by giving a true account of what has happened, he may be incriminating himself. So a magistrate under section 164 can record such confession also. But if you see section 164, lot of safeguards have been provided. First of all, he must say, whenever an accused comes with an application, orally or in writing, stating that he wants to confess and therefore he wants to give his statement, he must say, the judge must say, no, you are not bound to give such statement. He must also say, if you give a statement, that statement may be made use against you, and it will be detrimental to you. In spite of that, if he wants to give his confessional statement, he must say, come tomorrow. And he must also see whether there are any police officers standing in and around the court hall, because they may be persuading him, they may be pressurizing, and next day. That means he will have some time to think over. He will be sent back to judicial custody. He will not be sent back to police custody. He will be sent back to judicial custody. He will have time of 24 hours or 20 hours. By the next day, once again he will come. See, there is no inhibition. There is no law mandates that you should give a confessional statement, that I should record it. If I record it, it could be used against you in the same trial, and thus your rights may be prejudiced. Once again, have you coolly thought over all these things? Yes, sir. Then only he must say, after recording the statement in the question answer forum or in a narrative forum, then he must append a certificate below that. I so and so explained everything, and I am of the opinion that it was on his own volition. I have taken steps to see that no policeman was present. See, those sections, though it's a procedure, the rights of the accused are safeguarded. Normally, whenever a statement of an accused is recorded by a magistrate, it has a credibility. It has a greater evidentiary value. Any statement made by a witness under section 161 of CRPC, it is not signed. The witness who gives a statement before the police is not expected to put his signature below his statement. He may even say, give a go-by to what is stated by him before the police. At the best, he may be treated as a hostile witness with the permission of the court. See, some of the powers are given. For example, police can ask request the magistrate or the concerned judge for a police custody. Custodial interrogation may be required. That accused may be taken to the place where he is stated to have hidden something which was used in the commission of crime. You know how that statement will have to be recorded. Section 27 of the Evidence Act, which is an exception to Section 25 and 26 of Evidence Act. That part of the statement which has led distinctly to recovery alone is admissible in evidence. If the accused states that I used this sickle to slit the throat of A, so he can only say that will be inadmissible in evidence. That part of the statement will be admissible, which only distinctly leads to discovery. That means I have hidden a sickle in such and such a forest. So that portion only is to be proved. The manner in which the police are given powers, the exercise of the same is equally important. This CRPC contains something about the cognizable offences, non-cognizable offences, the forum of trial, framing and issuance of summons, framing of charges, and joinder of charges, amendment of charges, issue of summons and warrants, recording of evidence, bail provisions. Bail includes rejection of bail, whether bailable or non-bailable. Do you have any idea of bailable and non-bailable? What is bailable and what is non-bailable? You say, we generally it's a non-bailable offense. Non-bailable means not bailable at the police station, that's all. Court has power. Court has power. Even in murder cases, courts have granted bail, you know. Therefore, bailable offense means cases in which the police have the power to grant bail. So, cases in which police have no power to grant bail, they will have to produce the accused before the court, and court will decide in accordance with law, take many things into consideration as to whether an accused is entitled for bail at this stage, or if not, what is to be done. Bail, then recording of evidence, then after the closure of evidence of the prosecution, then examination of the accused under section 313 of CRPC. That is the only opportunity for the accused to explain his stand in the case. Many of you are riders. Probably, I hope none of you have met with an accident. Has anybody met with an accident while driving? Please? Okay. Okay. Are you an accused? Are you an accused in case? But you are victim. Okay, you are entitled for compensation. Let us assume. See, that is the only opportunity for many things. See, for example, it so happens, let us assume that a road where there are no dividers. One vehicle, one bus is passing at a high speed behind another bus. He wants to overtake the bus which is ahead. Therefore, in the spree of overtaking, he doesn't see as to whether any vehicle is coming on the opposite side. At last he notices that a bus has almost come and is likely to hit. Is it not? Then accident takes place. Let us assume, in order to avoid that accident, he takes that vehicle to the extreme right side, and few people are injured and he is also injured. Now we can explain. See, because accused can examine himself as as a witness. Law provides for them. Or he can take such defense which is consistent with the stand taken by him while cross-examining the material witnesses. because that will give him the benefit of doubt. He can say, if I had not swerved from the usual path, the gravity of the accident would have been more. All the inmates of the bus would have died. Therefore, in order to avoid that, and in order to avoid maximum injury and maximum casualty, I had to take it to the extreme right and hit against the tree. And if that stand taken by him is found to be palatable and consistent with the stand taken by him during the course of cross-examination, benefit of doubt would be given. Benefit of doubt, what is proof beyond reasonable doubt? It is the most vexed question in the criminal law. A lot of debate is going on. Only people say only 6% conviction, only 7% conviction. There are so many things in the Indian context that proof beyond reasonable doubt has a great significance. Only persons who have read criminal law very well will understand the significance of proof beyond reasonable doubt. So, proof beyond reasonable doubt is also, the preponderance of probability. All the evidence, whether in a civil case or a criminal case, is tested on the touchstone of preponderance of probability. But in criminal case, a little higher degree of preponderance of probability is insisted. And if the evidence placed on record is not one of proof beyond reasonable doubt, in spite of the deficiencies in the stand taken by the accused will be acquitted. So, one of the finest judgments written on proof beyond reasonable doubt is by Justice M.N. Venkatachalamaya, former Chief Justice of India, in Krishna Gopal versus State of UP 1988, SC, AR 1988, SC 2154. I have written an article. For your benefit, I can make it available to your law school. You can make use of this. This proof beyond reasonable doubt. Then CRPC contains provisions regarding appeals against conviction or acquittal, criminal revisions where there are legal infirmities, and extraordinary power of the High Court under section 482 of CRPC. Inherent, the power inherent under section 82 is only of High Court. It is not given to subordinate criminal courts. But in CPC, even a court of civil judge, that is the lowest court in the hierarchy, has an inherent power under section 151 of CPC. But that power is not made available to a magistrate. Because in spite of, if you go to section 482 of CRPC, you have voluminous decisions of constitutional courts, that is different high courts and the Supreme Court. If you go through all those decisions, if the judges in the High Court, who are stated to be very mature, can commit mistakes, and if such power is made available to a magistrate, please imagine what would happen. Therefore, inherent powers are not exercised, are not to be exercised by the magistrates or the sessions judges. It's only of the High Court, that too under extraordinary circumstances. Normal rule is not to invoke section 482, and exception is to use section 482 of CRPC. This code provides also for compensation to victims, and that compensation, the aspect of compensating the victim has undergone a sea change in view of Act 5 of 2009. Earlier, compensation used to be given to the victim only when the accused was convicted, and the two when the accused was capable of giving or paying compensation. 357(1), 2, 3. Now, 357A, because of the amendment in view of Act 5 of 2009, 357 is amended and A is added. What does it say? See, for example, let us assume A is the wife, B is the husband. She has two small children. She is living in a remote village. She has an aged mother-in-law. Somebody murders her husband. Somebody murders her husband. The bread earner is lost. The children have lost the love and affection. And wife has lost the consanguinity. Mother has lost the love and affection. And there is nobody to earn in the family. What should happen? Let us assume that the same man, instead of being murdered, dies in a road accident involving vehicles. The legal representatives of the deceased would get compensation. Is it not? And suitable compensation. Just and suitable compensation under section 165 of Motor Vehicles Act. Just suitable. Courts have gone to the extent of stating that just compensation has a greater significance. Let us assume that the compensation so awarded by the Motor Accident Tribunal is inadequate. Even in an appeal filed by the insurance company, the court has the power to enhance the compensation given to the respondents who have not filed appeal. I have written, of course, relying upon judgment, I have written one judgment while I was sitting in Gulbarga bench, Muhammad Imran versus NEKRTC. You can Google it. Muhammad Imran versus NEKRTC, decided on 19/12/2014. In that case, the NEKRTC filed an appeal against the quantum of compensation awarded to the victim. He was injured. And the injured had come to the court, and on hearing the parties and their counsel, I dismissed the appeal of the NEKRTC, that is Northeastern Karnataka Road Transport Corporation, and enhanced the compensation of the victim who had not filed an appeal, because Order 41 Rule 33 provides for same. That's how, see, compensation. But this was taken note of by Justice V.S. Madhivath Committee. They said, no, for no fault of him he is murdered. State has an obligation to provide some compensation to the legal representatives of the deceased, murdered, or to the injured. Therefore, 357 AFCRTC, notwithstanding the acquittal of the accused. Earlier, the requirement was accused should have been convicted. Then only there was scope for paying compensation. Now it is dispensary. Even in cases where accused is acquitted, state has a responsibility to compensate the victims of crime. Therefore, 2WA has a great relevance. As a result of this definition, even when, suppose, let us assume that in a case accused is acquitted, state doesn't prefer an appeal. Victim can prefer an appeal. Victim can prefer an appeal. Earlier there was no opportunity for a victim to file an appeal or revision as the case to be. Now, in view of this, in the light of the enhancement of the victim, in view of section 2WA, he can file a revision or an appeal as the case to be, and the court is bound to consider the same as though it was filed by an accused. It can definitely go into the niceties. Now, what has happened? Now, 357A has given a responsibility to the respective state governments to create a fund for suitably compensating the victims in consultation with the State Legal Services Authority. Whenever a victim is accused is acquitted, the court which acquits the accused has a duty to award compensation, and if it does not want to award compensation, it has to give reasons. Normal rule is to award compensation to the victims in all cases where accused are acquitted either because of the absence of proof beyond reasonable doubt. That is Shivajirao Ankush Gaikwad's case. Supreme Court has specifically had. I prepared a very elaborate article. I think if it is useful, you can make it available to your dean. Please make this. This is very important. There may be, and a law has a new dimension is added to the CRPC in view of section 357A. And what has happened? See, there are different. So for murder in one state, 3 lakhs is given. In some state, 2 and 2.5. In some states, 2. That means the schedule of compensation to be payable to the victims differs from one state to other. Therefore, Supreme Court in Suresh versus Haryana, State of Haryana, 2015, Honorable Mr. Justice Goyal, A.K. Goyal, has specifically said that the maximum compensation payable to different kinds of offences is of Kerala, and a direction is given to all the states to follow the Kerala schedule. So therefore, that decision of the Supreme Court is a binding precedent under Article 141 of the Constitution of India. The Supreme Court has the power to make a law, till law is made by the legislature of the Parliament. So, 141. It is a binding precedent. I think now all the states are trying to revise their schedule so as to fall in line with Kerala, and therefore the compensation to be paid to the victims in respect of various kinds of offences would be similar, identical. Friends, warrant case to be tried before a magistrate is almost synonymous to a case to be tried by a sessions court, because it is, as already explained to you, there is only 2 types of cases: summons cases, warrant cases. So warrant cases will be tried by magistrates courts also. They will be tried by sessions courts also. Such warrants case which are tried by sessions courts, they are called as sessions trial. Only difference is that a public prosecutor will conduct a trial on behalf of the prosecution in the sessions court. Whereas the court, as also in sessions case, there is absolutely no difference. The difference is in regard to this summary trial and the warrant trial. Summary trial, only summary of the evidence will be recorded. Let us assume A has issued a check to B, and the check issued by A to B has policy as to, and he had issued a notice calling upon him to pay back the money. He will only say, A had issued a check to B for a consideration of ₹10 lakhs, and the check was drawn on such and such a fact, having such and such a date. The same was presented to the bank, and it is bound for insufficiency of funds. 5 lines, 6 lines are maximum. 1 paragraph would be sufficient, because what is told, what is deposed by the witness would be summarized. Summary trial means summarized, and it will be in a capsule form. But in a warrant trial, no question, it's a narrative. At times it could be some question answer should also be found. And trial in respect of relating to offences against women and children will be invariably recorded in camera. If it is a case of rape, if it is a case of an attempt to outrage the modesty of women, or if it is an offence under POCSO Act, all such cases will have to be conducted, evidence will have to be recorded in camera, because nobody should know about them. In rape cases, the name of the victim should not find a place in the judgment. We only say we, victim, we. I think some High Court of Delhi has taken serious objection to the names of victims being published in some rape cases. No, nobody should not be made. And you see, there are 2 types of cases. One is instituted on the basis of police report. That means regular police filing charge sheet under section 173 of CRPC. 173 contains the various details of the charge sheet to be found. Whereas this 173. Other cases instituted otherwise than on a police report. For example, a private complaint, we say complaint. Normally, A goes to police station and lodges his, we will say lodges his complaint. Strictly speaking, the word complaint should not be used because the victim or somebody who knows something about the incident only gives a report. That report is under section 154 of CRPC. But if the same man goes to a magistrate and reports, it is called as complaint. Complaint is defined under section 2D. Complaint under section 2D of CRPC is defined as one given to magistrate and not given to the police. But normally in the normal parlance we use the word A went to police station, lodged a complaint. That's all. But strictly speaking, the word complaint is inapplicable to the police. Police would be a complaint before the magistrate. Police would be a complaint before the magistrate. So we'll say, therefore we call Banaswadi police versus Rajanna. So who is the complainant? Banaswadi police is the complainant. But report is made by A. A goes and states and reports to Banaswadi police station, which registers an FIR and sends it to magistrate. Then police becomes the complainant. Friends, have you got anything to ask about any clarification, any doubt? How many of you, after your course, how many of you intend to go and start as advocates? Please raise your hands. You have some of you might have already decided. Please, only few. So 7-8%. Okay. Are you interested in becoming advocates purely on criminal side? Because there may be advocates who are practicing mainly on criminal side and their children might be here and they may be interested in becoming advocates practicing mainly on criminal side. May I know, is there anybody who comes from a lawyer's family? Lawyer. Okay. Lawyer who is exclusively dealing with criminal case? Oh, 2%. Okay. People say that practice on criminal side is not, the ladies are not cut out for practicing on criminal side. Because everybody knows and then you will have to see only the offender and the various types of offences. Therefore, normally girls do not go to criminal courts. There is no inhibition as such. They do not, by virtue of their nature, they do not go to criminal courts. If you go to magistrates courts here, even gents won't go like going to magistrate courts. If I am asked to go there, I don't feel like going there. That's the atmosphere. Okay, you will have to be thorough. Whoever wants to practice on civil or criminal side, be thorough on procedural aspects. Because those procedures have the backing of the Constitution. If those procedures are violative of any of the provisions of the Constitution, they will be struck down. Because we will say bail. If a person who is entitled to be released on bail as a matter of right in a bailable offence, if he is denied of bail, the magistrate would be committing contempt of court or violating the provisions of Article 21 of the Constitution of India, because a man has an indefeasible right of being enlarged on bail in the police station itself or in the court itself. And if the court doesn't grant him bail, what should happen? It's a violation of Article 21 of the Constitution. It so happened, and now I am in Karnataka Administrative Tribunal dealing with service matters. One of the charges leveled against a police officer was that he had arrested somebody in connection with a case registered for offences punishable under section 324 and 341 of IPC in year 2005. He had arrested and produced the accused before the magistrate, and he had been remanded to judicial custody for 14 days, and on the last day, that is on the 14th day, he did not file another remand application, as a result of which he was enlarged on bail. Therefore, he committed a misconduct punishable under Rule 3 of misconduct rules. So he was found guilty. 2 increments had been, annual increments had been withheld with cumulative effect. Appeal filed against that penalty order was also dismissed. Thus, he had come before you. I just put a question. Sir, have you seen the CRPC? I got CRPC and gave it to him. So both these offences are bailable offences. That means if the offences are bailable, the police himself should have released him on bail, or at least the judge should have released him on bail. If the judge did not, if the judge before whom the accused was produced and did not release him on bail on the very day of his production, judge was wrong and no charge could have been framed there. So I allowed the application and the order of penalty was set aside. Therefore, you will have to be thorough with procedures, whether it is civil procedure code or criminal procedure code. These procedures, though they are not substantive law, they have greater sanctity in view of the constitutional backing. For example, many amendments were carried out to Civil Procedure Code and they have come into effect on 1/7/2002. The constitutionality of the amendments brought out to CPC was challenged before the Supreme Court, and in Salem Bar Association case 2003 as well as 2005, the Honorable Supreme Court has upheld the constitutional validity of the procedure. Therefore, procedures can't be ignored. Can't be ignored. For example, let us assume that a statement of an accused is recorded in police custody and for recovery of something. Now, if it is made up that he had been detained for more than 2 days, he could be detained up to 24 hours and he should be produced. And if the accused is able to say that he had been detained for more than 24 hours, then it will be in illegal custody. Any recording of statement done during illegal custody has no relevance. That is how law is built. Anything? Thank you. I will make available the article on victim compensation, as also a small note prepared by me in regard to nature of trials and summons case and warrant case. If it is useful, you can make use. Thank you.